All right, all right, all right. Hello, everyone. Can everybody hear me in the last row back there? Somebody wave. All good? Excellent. Well, before we begin, we wish to acknowledge this land on which the Henry N.R. Jackman Faculty of Law operates. For thousands of years, this has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. And today, this meeting place is still the home to many Indigenous peoples from across Turtle Island, and we at the Faculty of Law are grateful to have the opportunity to work, to teach, to learn, and build community together in a good way on this land. So, welcome. This is the most exciting, and I think it's safe to predict, and this already came across just hearing the vibe in the room, the most energetic event of the mooting calendar, the Grand Moot. It's a long-held U of T law tradition, a highlight of not just the mooting calendar, but the academic year. And that is for a number of reasons, including the fact that 4 of the law school's most talented mooters make their submissions to a truly distinguished panel of Canadian jurists. You will have seen in the program there's a particularly interesting and challenging scenario before the mooters and the bench today, that is charter applicability and double jeopardy in self-governing Indigenous communities. I will not introduce our distinguished bench, and that is simply because the Moot Court Chief Justices will do this, and likewise I will leave it to them to introduce our fabulous mooters. But I did want to say thank you to Kate Shackleton and Nafia Sheth, who have done an enormous amount of work and thinking and ideas bandying about in planning this event for months and months. That is, they've done an endless number of things, small tasks, large tasks, including the drafting of the problem, the bench memo, delivering the documents to the justices' chambers, and then organizing also the reception that will follow this moot. So there's a whole array of different skill sets involved here, and you will see in a moment how important this is to the success of this event. I also wanted to thank all of the many faculty members who've been involved along the way in working with the mooters, and also the chief justices of the court in developing this problem and honing arguments and so on. And then, not least, I wanted to say a thank you to the gracious host of this evening, our law firm sponsor, that is McCarthy Tetro. As anybody who's been at a Grand Moot before will know, McCarthy's has been involved with the moot for a long time, and they've also, aside from supporting the moot, have been engaged a number of people at McCarthy's in planning for tonight, and that's especially Liliana Stanic, Holly Kallmeyer, and Chris Puskas, and also, again, working with our mooters, and so this truly is a team effort. I wanted to say a quick shout out also to Aviva Lev-Aliv, our events coordinator, who's devoted many hours to make everything run smoothly. And now I would like to invite the partner and leading litigator with McCarthy Tetro, and that is Sarit Batner, to the stage. She will say a few words, and then we will hear from our Moot Court Chief Justices, who will introduce the bench and the mooters and say something about the proceedings.
Well, thank you very much. I will say very few words so that we can get on with the programming, but I'll just say this. My name is Sarit Batner. I was a student here from 95 to 98. I was a Grand Mooter myself in 1997, which is an impossible 28 years ago, and many of our litigators at McCarthy's were Grand Mooters. We have a tremendous amount of pride in U of T in particular, in the mooting program generally, and in the import of mooting and the exercise of mooting to becoming lawyers, whether you're going to be litigators or whether you're going to practice some other area of law. There really is something to the activity of mooting and really leaning into and delving into a problem in that way. So we feel it. We're delighted to sponsor this event. Again, I got to tell you, when I was a student mooting this event 28 years ago, McCarthy sponsored it then, and we've sponsored it since because we think it's so important. So thank you all very much for having us. We're delighted to be here and with you in all of this. And without any further ado, I will pass it over to the Chief Justices.
Thank you. So my name is Kate Shackleton, and this is Navya Sheth, and together we had the pleasure of serving as the co-chief justices for this year's Grand Moot. So we have a lot of people to thank for helping us get to this point, and first, of course, is McCarthy Tetro, who is such a generous sponsor of this event every year, and their support is truly what makes this all possible, so thank you. We are especially grateful to Holly, Chris, and Liliana for their support every year. We'd also like to thank the bench clerks, along with our inaugural group of junior bench clerks, for the research and drafting assistance that they provided. This was a very research-intensive problem to create, and their support was incredibly helpful. We're also incredibly grateful, as always, for the time and expertise provided by faculty members, whether that was reviewing the problem or judging a run-through. It was much appreciated. Finally, we'd like to extend a very special thank you to Brandon Montour. Brandon is an SJD student here at the faculty and a member of the Ganawake community. His knowledge and experience was extremely valuable for us. We spoke to him many times, and we had many more questions that we communicated to him over email, and we could not have written this problem without him.
So on that note, while the moot today concerns a fictional fact pattern, it's set in a very real community in Ganawake. So Ganawake is one of 8 communities that makes up the Mohawk Nation, or the Ganyangehaga, and they are themselves a part of the Haudenosaunee Confederacy. The traditional territories of the Mohawk span from what is now New York State to the St. Lawrence River in present-day Quebec. The reserve of Ganawake sits on the St. Lawrence River, about 10 kilometers south of Montreal. The Ganyangehaga are governed by Haudenosaunee law, which includes, but is certainly not limited to, the Great Law of Peace, the Covenant Chain, and the Two-Row Wampum. Ganawake and the Mohawks have governed themselves in accordance with these laws since time immemorial. They do not have a self-government agreement with the Canadian state, and instead exercise their jurisdiction over their own territory.
This year's Grand Moot problem considers the relationship between self-governing Indigenous nations and Canadian law. The problem is set, as we mentioned, in Ganawake, along with the province of Falconer in the country of Laval, which are respectively equivalent to Quebec and Canada. The appellant, Kate Sheth, is a resident of Chateauguay, which borders the Ganawake Reserve. One night, Ms. Sheth decided to drive home from visiting a friend on reserve while under the influence. She veered off course and damaged the community garden in Ganawake. Once off the reserve, Ms. Sheth was charged with impaired driving. She pled guilty and was sentenced in the provincial court of Falconer. Subsequently, the respondent Mohawks of Ganawake sought to involve Ms. Sheth in their community restorative justice process, known as Skana Anazandu. She initially consented to this voluntary process. Through this process, it was determined that Ms. Sheth breached the Haudenosaunee legal principle of righteousness. Additionally, the process resulted in a set of consequences. Until she complies with these consequences, she is barred from entering the reserve.
After participating in the Skana Anazandu process, Ms. Sheth became aware of her Section 11H right to be protected from double jeopardy. She decided to challenge the constitutionality of the proceedings and argued that both the conviction and the imposition of the punishment constituted a breach of that Section 11H charter right. After winning at first instance and then losing on appeal, Ms. Sheth now appeals to the Supreme Court of Flavel. The appeal addresses the following 3 issues. First, whether the charter applies to Ganawage as a nation that does not exercise delegated authority from the Canadian government. Second, whether the proceedings in Ganawage constitute double jeopardy in light of her pre-existing conviction in Flavel. And finally, whether Ganawage has a Section 25 right to self-government over criminal matters that shields the infringement. At this time, we ask that you set any electronic devices to silent, and we ask that nobody please leave the room during the moot. With that, we have the pleasure of introducing our justices for this evening. We're honored to be joined by Justice Sheila Martin of the Supreme Court of Canada, Justice Rennie Pomerantz of the Court of Appeal, and Justice Robert Senta of the Ontario Superior Court of Justice. We'll now turn the floor to the mooters. Once again, this year's Grand Mooters. For the appellants, Akash Jain and Sarah Zaitlin, and for the respondents, Ikran Jama and Matthew Farrell. Thank you.
All rise for the Honorable Justices of the Supreme Court of Flavel.
Please be seated. Good afternoon and welcome to the Grand Moot. Counsel, pleases the court.
At the heart of this case is a simple question. How far do constitutional rights extend? Is the right to be free from double jeopardy simply lost when one steps foot on Indigenous territory? Should Indigenous governments that have the power to violate individual freedoms be insulated from our Constitution's most basic safeguards? No, Justices. Ms. Sheth stands before this court seeking no more and no less than the fundamental rights each and every Flavelian citizen is owed. In October 2023, Ms. Sheth drove out of Ganawage while intoxicated, damaging part of a community garden. She was punished, arrested, and tried by Flavelian authorities. Ms. Sheth now faces further consequences imposed on her by the Ganawage. Ultimately, Ms. Sheth is being tried twice for a singular wrong. Justices, I have 2 primary submissions for you this evening. First, I'll demonstrate that the Flavelian Charter of Rights and Freedoms does, and from a normative standpoint should, apply to Ganawage. And second, I'll demonstrate how Ms. Sheth's Section 11H charter breach is not shielded by Section 25 of the Charter. And our submissions on Charter applicability begin at paragraph 19 of the appellant factum. I'll make 3 primary points as to why the Charter applies to Ganawage. First, Ganawage is a government by nature under the first branch of the Eldridge Framework. Second, Section 32 doesn't expressly preclude Charter application to Ganawage. And third, the purpose of the Charter to mediate the power imbalance between the governed and the governing must animate our interpretation of Section 32. And in my submissions, I'll make clear how power imbalances persist in Ganawage. So to begin, Ganawage is a government by nature, and this is at paragraph 20 of the appellant factum. Now, according to Dixon, the most recent Supreme Court of Canada case dealing with the Charter's applicability to Indigenous communities, courts typically rely on 4 Godbout factors to determine whether an entity constitutes a government by nature under this branch. Whether there's a democratically elected council, whether the entity in question possesses the ability to implement taxation policies akin to Parliament, whether there's an ability to enforce coercive laws, and finally, whether there's overlap with federal or provincial jurisdiction delegated by either the federal or provincial government. And for the reasons of Justice Hazra of the Superior Court of Falconer, we largely agree that the first 3 Godbout factors apply to the case at bar. And with leave of this court, what I'd like to do is spend most of my time focusing on the last Godbout factor, this delegated authority factor, as this seems to be the primary source of disagreement between our friends and I. Now, we do acknowledge, Justices, that there are some key distinctions between the case of Dixon and in our case. In Dixon, there was a self-government agreement, and here we don't have a self-government agreement. However, the majority...
But, Counsel, on the 4th Godbout factor, do you accept that you need an express or implicit delegation from a federal or provincial authority?
Justice Martin, our position is that according to the majority in Dixon, there was a need for express or implied delegation. However, our argument doesn't hinge on the fact that there's delegated authority. Our first argument is that the 4 Godbout factors are readily satisfied, and in the alternative, based on a purposive reading of Section 32, the Charter should also apply to Ganawage, and I'll focus on those submissions. And Ganawage derives authority from governments in 2 primary ways. The first way Ganawage derives authority is from the provincial government through framework agreements. And I'll let our factum speak to this submission. The second way in which Ganawage derives authority is from the federal government through the Indian Act. And as we know, the Indian Act is a piece of federal legislation. And the MCK, the Band Council of Ganawage, which is generally accepted as a legitimate form of authority within the community, and indeed represents the Ganye Gahaga in external relations. That Band Council was elected pursuant to terms of the Indian Act. And indeed, this Band Council exercises Section 83 powers under the Indian Act. It's the only body that the government of Flavel recognizes, and our jurisprudence is clear that band councils are creatures of the Indian Act, and band councils exercising authority under the Indian Act are subject to charter scrutiny, and we believe the same should apply in the case at bar.
But that council didn't drive either the law or the process in this case, did it?
Justice, our position here is that the CDMP, this community decision-making process, although it arguably cuts against this argument, the CDMP was established at the behest of the MCK, the Band Council. The Band Council still exercises a considerable degree of control over this consensus-based decision-making process, and according to an article by Professor Horn Miller, who's an academic as well as a member of this community, the Band Council, the MCK, determines the nature, scope, mandate, and intent of sector-specific legislation that flows through the CDMP. And additionally, the MCK chief represents community members that are not, that a law potentially implicates. So in our view, the MCK still wields considerable authority in the enactment of this community decision-making process. Now, we recognize that one of the reasons in Dixon, Justice Rowe held that the charter shouldn't apply to the Wet'suwet'en First Nation was because the constitution of this Wet'suwet'en First Nation, they removed band council governance. And here we still have an operational band council, and therefore it's our submission that under delegated authority from the federal government, the charter ought to apply to Kahnawake. And justices are...
But should something as fundamental as whether individuals possess the rights of the charter be subject to granular examination as to who has what power, when, over what, whether it's a modern treaty, an ancient treaty, or whether it is somehow, in some person's mind, a product of one government transferring to another?
Justice Martin, we recognize that the Godbout factors, particularly this last one, may not make sense in this particular context, especially when we have an Indigenous community like Kahnawake that is attempting to exercise certain self-government powers. And in that case, it's still our position that the charter ought to apply to this community when we consider the text of the charter, and going back to the concurring decision in Dixon by Justice Martin and Justice Obansewin, when we consider the purpose of the charter, this power imbalance. And I'll demonstrate how their power...
But didn't Godbout and Eldridge also talk about a purpose of interpretation? So why aren't the specifics of those cases more important than a concurring judgment?
Our position here, Justice Martin, is that even in those cases, the locus of action for the Supreme Court of Canada, they did recognize that there was a delegated form of governance. However, for example, in Godbout and McKinney, the Supreme Court of Canada, the majority emphasized that if the charter is to apply to municipalities, which it does, it's because municipalities exercise a quintessentially governmental function. And we also see this in the case of York Region, where the Supreme Court of Canada held that the charter applies to Ontario public school boards because they are inherently governmental. So our position is that Kahnawake exercises matters of authority within the legislative competence of the federal and provincial government. And we see, for example, with the Greater Vancouver Transportation Association case at paragraph 14, entities exercising matters within the authority of these heads of government should fall within the charter, regardless of whether there's this delegated source of authority.
Isn't the element of coercive governmental action missing where we have a process that's predicated on consensus and collectivity? People have a choice as to whether they participate, and indeed the community is involved in the crafting of the laws and the process itself. And so aren't we dealing with a situation where the coercive element of government, which is really what the charter is concerned with, is absent?
Justice Pomerantz, we do acknowledge that point. However, in Kahnawake, there are still coercive elements at play. So although, let's take the justice system, for example. We have this Justice Act that was passed pursuant to the community decision-making process. And although Skana Anizandu, according to Section 6.1 of the Act, is the entry point, the Kahnawake, the Kanien'kehá:ka, still have an established court system that can impose penalties and fines and imprisonment. And therefore, there are still coercive pressures that do exist within this community. And I think going back to an earlier point I made, although the CDMP, its objective is ideally for consensus-based decision-making, these objectives are often not realized in practice. And the literature shows, and this is at the official problem, paragraph 8, it prioritizes those that are well-organized, well-resourced. The CDMP suffers from low participation levels, and there is not a lot of diversity of viewpoints within the CDMP process. And a manifestation of this, for instance, is the membership law. So this was a law passed pursuant to this community decision-making process. And according to the membership law, a Mohawk family that adopts a non-Mohawk child is essentially banished from the community. So we see the clear tension between the Indigenous right to preserve Mohawk identity, but also the individual right to retain one membership. And this is especially dire in this case because when we compare this case to Dixon, in Dixon, there was a self-government agreement and there was a constitution. And Article 4 of that constitution provided for a number of individual rights and freedoms, many of which emulated charter rights and freedoms. Here we have no constitutionally protected rights regime. And again, according to Justice Martin and Justice Obansewin, in Dixon, we should be especially cautious, and this court should be especially cautious about sanctioning rights-free zones, particularly in Kahnawake.
Would the charter not apply if there was a rights document in place?
According to Dixon, the charter would still apply. So we see with the Wet'suwet'en First Nation, both the majority and concurring opinions held that the charter still ought to apply to this First Nations, even though they had some semblance of a charter. That would be a different set of facts, and while there may be instances in which the charter won't necessarily apply if there is some baseline level of rights protection. The problem here, and as identified by Justice Martin and Justice O'Bonsawin, there needs to be some floor, some baseline level of rights protection. And the factual record here furnishes no evidence of that, and therefore it's especially important that we implement the charter in this case. So barring any questions, I'll now move on to the second reason why the charter ought to apply to Kahnawake, and this begins at paragraph 32. That the text of Section 32 doesn't expressly preclude charter application. When we look at the text of Section 32, nowhere does it say that the charter only applies to the federal government, the provincial government, parliament, and the legislatures. And indeed, at paragraph 48 in Godbout, Justice Laforêt was clear that interpreting Section 32 as including governmental entities other than those explicitly mentioned within the text of Section 32 is sensible from a practical perspective. And also, the majority in Dixon at paragraph 48 recognizes that Section 32 ought to be interpreted generously as opposed to narrowly, technically, or legalistically. And as I mentioned earlier in our jurisprudence, we see that the charter applies to a number of bodies that are not expressly mentioned within the text of Section 32. So transit authorities, Ontario public school boards, municipalities. And therefore, just because Indigenous governments are not explicitly mentioned in the text of Section 32 shouldn't prevent this court from concluding that the charter ought to apply to an Indigenous community like Kahnawake. Finally, and I think this goes back to your question, Justice Pomerantz, the third reason why the charter ought to apply in this circumstance is that power imbalances exist within the community. And this starts at paragraph 37. The purpose of the charter here really is the guiding light. And especially, as I mentioned, we're operating in a somewhat unique situation in which Indigenous communities are attempting to exercise certain self-government powers. And therefore, it's important that this court take a step back and consider why the charter was enacted in the first place. And the charter was enacted to prevent this power imbalance and hold the government to account. And
is that the question when we're thinking about the intent of the framers in extending the charter, not about its terms, but to whom it applies? And what in the text and structure of the Constitution suggested at the time it was enacted there was any expressed intention to have it apply in circumstances remotely similar to this?
Justice Senta, we appreciate that point. As Justice Martin and Justice O'Bonsawin recognize in Dixon, at the time the charter was enacted, Parliament, the legislatures, the provincial and federal governments represented the entire legislative universe. And we've seen through our history Indigenous governments taking on more governmental responsibilities as time progresses. And additionally, the majority also recognized the draft legal text of the Charlottetown Accord indicated that Section 32 should include Indigenous communities. Ultimately, this was struck down with a national referendum, but it's still noteworthy, and the majority recognizes this in Dixon, that there is some compatibility between even inherent Indigenous self-government and charter applicability. And in fact, there were a number of Indigenous communities, for example, the Assembly of First Nations, the Métis National Council, that agreed that the charter ought to apply to Indigenous communities.
How do you meet your friend's argument that they don't know how to affect a legal result that is in favor of reconciliation? How do you deal with that?
So we recognize that the reconciliation argument cuts both ways. Our position here is that by applying the charter to Kahnawake, it's a natural extension of the governmental powers that this Indigenous community is exercising. And additionally, if anything, it fortifies the legitimacy of their governance structure. And we see, for example, with the Bill C-92 reference and in Delgamuc, let's face it, we're all here to stay. So we need to recognize that there is this inherent braiding together of different legal orders, indigenous legal orders, Flavelian legal orders, and Falconer legal orders. And therefore, it's clear, and our jurisprudence is also clear, that Indigenous communities are not separate foreign nations. They're enmeshed within Canada's constitutional framework. They're part of Canada's constitutional architecture. And because they are governments, like all other governments, they should be subject to the Charter. So seeing that we have only a few minutes left, I'd like to now move to my submissions on Section 25, barring any further questions from the court.
Why is this a difference when it's targeting very similar conduct?
Is this getting at the irreconcilable conflict? Yeah. So there's a few positions here. First is that our position is that there is no irreconcilable conflict, and it's important to recognize at the outset that this is a high bar for our friends to meet. The conflict must be unavoidable, non-hypothetical, and it must undermine Indigenous difference in an essential or non-incidental way. And one of the primary reasons why accommodating for double jeopardy doesn't undermine Skana Anizandu is that we see there was a 2023 memorandum of agreement between the Director of Penal and Public Prosecutions of Falconer and the Ganye Gahaga that allowed for minor crimes to flow through Skana Anizandu without being tried in Falconer. And therefore our position is, and we also see a number of agreements where there's a sharing of jurisdiction between Falconer and Ganawage. And therefore, in the spirit of reconciliation, it is our belief that the government of Flavel and the government of Falconer will start carving out more space to allow the Ganye Gahaga to adjudicate criminal sanctions according to their own criminal process. And in that sense, there would be no irreconcilable conflict. And the second way in which there would be no irreconcilable conflict is all criminal powers have some limits to accommodate for multi-jurisdictional overlap. This was recognized at one of the lower courts, and we agree here. Just because these limits exist, that doesn't derogate from the sovereignty or the ability of a nation or a community to adjudicate transgressions according to their own criminal processes. In conclusion, the Charter applies to Ganawage based on a straightforward application of the 4 Godbout factors and a purposive reading of Section 32. And secondly, Ms. Sheth's Section 11H charter right is not shielded by Section 25 of the Charter because of the fact that the claimed right to self-governance over criminal matters doesn't fall within the ambit of Section 25. I know we didn't get to this in my oral submission, so I'll let our factum speak to that. And as I mentioned to Justice Martin, there exists no irreconcilable conflict between Ms. Sheth's Section 11H right and Ganawage's claimed right. I'll now turn the floor over to my colleague, Ms. Zaitlin, to discuss our submissions on Section 11H.
Thank you, Mr. Jain.
Thank you, Justices. Allow me a moment to get situated.
Allow me a moment to get hydrated.
Are we ready to begin?
Yes, we are.
Thank you. Good evening, Justices. Sometimes, when a consequence looks like a criminal punishment, and it functions like a criminal punishment, it simply is a criminal punishment. That is the case here. Skono Arizodu is a criminal process that amounted to a criminal punishment or imposed a criminal punishment upon Ms. Sheth. When Ms. Sheth drove while intoxicated, she violated not only Flavelian criminal law, but also the Haudenosaunee principle of righteousness. Ms. Sheth should face criminal consequences for her actions, and she did, when she was tried and punished by the provincial courts of Falconer. However, it is a violation of Ms. Sheth's Section 11H rights to be free from double jeopardy, to be tried and punished twice for the same offense, and that is what is happening here.
So can I stop you there?
Certainly.
How is it that you get to raise this argument now? As I understand the facts, Ms. Sheth voluntarily agreed to participate in the process. She participated in the collaborative process and accepted that consequences might apply to her. She says that she was initially unaware that her charter rights applied. But the law imposes, for example, no duty to speak to the police. And where Section 7 protects the right to silence, if a person goes to the police and blurts out a statement, Section 7 can't be subsequently raised at trial to exclude that evidence on the basis of a breach of Section 7. Here, Ms. Sheth voluntarily chose to participate essentially because she did not know of her right. Why isn't that just a mistake of law, the type of for which we give no appellate relief? And how can she now assert a charter right that appears to be spent?
Certainly, Justice Senta. The issue of Ms. Sheth's voluntary participation in Skona Adezodu amounts to some discussion of the doctrine of waiver here. It only becomes relevant in our consideration of Ms. Sheth invoking her Section 11H rights, at the point at which we accept that by voluntarily participating in Skona Adezodu, Ms. Sheth waived those 11H rights. However, the doctrine of waiver is clear in the case law, we know this from Edwardson, from Corpinay, that to waive an individual's charter rights through voluntary participation, that waiver must be informed, clear, and unequivocal. Here, there's no dispute on the evidence that Ms. Sheth did not know that she had Section 11H charter rights. She could not waive them clearly and unequivocally at the time because she did not know they existed. We recognize that Skona Adezodu is intended to be a voluntary process and that a lot hinges on that. However, there is a certain coercive nature that is baked into the Skona Adezodu process. It is contemplated by the ban that Ms. Sheth faces if she does not participate in the first two components of the criminal sanction that she received. If she does not pay the $500 fine, if she does not serve the time repairing the garden, she faces a ban from the reserve. That indicates that Skona Adezodu contemplates the necessity of having teeth, of having a coercive nature, that individuals may not want to participate so voluntarily throughout, they may want to pull back. It is for those reasons, both the doctrine of waiver, that we see that Ms. Sheth is able to assert her 11H rights here now, and because we dispute this characterization that her participation was truly voluntary throughout, that we're able to raise the Section 11H issue here.
Your argument on what is punishment focuses on the fine, but it was but one aspect of the disposition. There were the weekends she would have to spend paying for supplies, and I'm wondering what the impact would be on your argument if there had been no fine, but the other sanctions had been imposed.
Certainly, Justice Pomerantz. To clarify our position on whether or not the Wigglesworth test, whether or not the sanction was criminal as a whole, whether or not the threshold for Section 11 is met here, does not rest solely on the fine. We rest on the fine for the true penal consequence component of the Wigglesworth test, but both need not be satisfied. For Ms. Sheth's Section 11H rights to be implicated, we must prove that the process is either criminal in nature or that it is a true penal consequence. While we rest on the fine for the true penal consequence, our submissions that the Skona Adezodu is a criminal process in its nature stand alone. I will get into those in a moment, but first I would rather address the second part of your question, why we ought to consider this punishment as a whole and why we separated out the fine for the true penal consequence level of the analysis. The answer for why we separated out for true penal consequence is a practical one. Historically, courts have only really considered, at that stage of the Wigglesworth analysis, fines or imprisonment to be true penal consequences. But we don't rest on that for the balance of our submissions, particularly as it relates to the KRJ analysis. For the purpose of the KRJ analysis, as to whether specifically the protections of Section 11H should be invoked, it is appropriate to consider the consequences of Skona Adezodu as a whole, which do include all of its component elements. That means the $500 fine, the time she must spend repairing the garden, and if she fails to meet these two conditions, the ban that Ms. Sheth faces from the Ganawage Reserve. It was the esteemed Justice Martin in Boudreau, who articulated that we ought to consider the knock-on effects of criminal consequences when considering their impact, and that is why consideration of the ban is relevant throughout the KRJ analysis.
But in Boudreau, the knock-on effects were detention and imprisonment. Here, can she not perform photography elsewhere? Can she not, I mean, is this the same kind of knock-on effect as was considered in Boudreau, which really related to a true restriction of liberty in every sense?
That is true, Justice Pomerantz. The knock-on effects are significantly different. But we ought to again take a step back here and situate ourselves in the analysis. The knock-on effects of the ban are not relevant at the point at which we're considering the threshold for whether or not skono adezodu is a criminal process in its nature. Those stand alone. The ban is relevant at the point at which we look at the third branch of the KRJ test, whether or not the consequences of the process, that being skono adezodu, significantly impact Ms. Sheth's liberty interests. While they are not the same, it doesn't amount to imprisonment. We've seen in other instances of case law that other punishments that don't amount to imprisonment or true penal consequences don't have to meet that same standard. For example, we look at KRJ, where the court found that living in a community under restrictions, that being not to contact individuals under 16 and not to access the internet or certain places on the internet, amounted to a restriction on the individual's liberty. We see that the standard that's being applied there for what impacts a liberty interest, even what significantly impacts a liberty interest, is not the same standard as what amounts to a true penal consequence.
But can we get back to the Ganawake Justice Act, which states a restorative justice rationale? Does that put a patina over even the totality of the punishment, that take it out of a punishment model because it doesn't have retribution as its cornerstone?
No, Justice Martin. We submit that it does not take it out. And the reason for that is multifold, more than twofold.
Okay, give me all the numbers.
Give you all the numbers. All right, here we go. First and foremost, skono adezodu is tailored. It's intentional. It was not a mistake that the consequence has multiple components. It includes those restorative aspects, that being the time spent repairing the garden. It also includes something that looks a little bit more punitive, that being the $500 fine, or perhaps typically punitive. And it also includes teeth, the ban that Miss Sheth faces if she does not partake in the reserve. Partake in repairing the garden on the reserve. There is space in the analysis to consider all of these sanctions, and the purposes for imposing all of these sanctions together. And in fact, it is both consistent with the purposes of reconciliation and consistent with the principles articulated by the court for us to be doing so. The KRJ test is intended to be broad. The Supreme Court articulated that in KRJ that a liberal and purposive approach must be taken to defining punishment. When we take that liberal and purposive approach, we see that there is space to consider these sanctions together. And in fact, we should consider these sanctions together, given that it is not an accident that they were all imposed at once. The Ganyigahaga people gave effect to both the restorative nature of their justice system, but also a more coercive element and a more punitive element by intentionally imposing them all at once. These sanctions cannot be separated from one another because we are giving better effect to the intention of the Ganyigahaga by considering all of them as they were intended to be imposed. That is consistent with the broad and liberal approach.
Would Justice Fish and Martineau agree with you? I mean, taking it all into account, I mean, he had some very specific prescriptions of what criminal proceedings required, laying of charges, you know. So how do we reconcile that authority?
Martineau is an older case, and there's a reason that we call it now the KRJ test, and there's a reason we refer more frequently in jurisprudence to Guindon and KRJ. It's because our principles evolve, right? The application of our charter rights here has been trending more towards recognizing this broad and liberal approach and understanding that this is perhaps the way that we've seen jurisprudence trending in this direction. We take, for example, Big M Drug Mart. We want to give effect to the purposes of the charter. And here, when we consider our Section 11, in particular our Section 11H rights, we don't want to neglect the intention of the drafters when invoking Section 11. We want to give effect to the possibility that individuals will face dual legal jeopardy, and we want to provide those protections.
I have a question, and I'm going to ask it of your friends, so it's a little harder for you because you're getting it first. What happens if, in this particular fact situation, the Ganawage process happened first?
Certainly. We see from the existence of the framework agreement between Falconer and Ganawage that to some extent this is contemplated. Our submissions do not change. If the Ganawage process happened first, if Ms. Sheth had been subjected to Skona Adizodu, it is our submission that then the courts of Falconer would be precluded from trying her again because her double jeopardy rights would be invoked. We recognize that to an extent we are limited by the factual record before us, and the analysis might look
We'd like to
different.
understand how the rules operate either way.
Certainly. Right? Perhaps that would be better answered if I take a step back and return to my submissions on why Section 11 protections apply broadly, why we submit that they are invoked here. We already addressed to some extent the true penal consequence discussion, and only one needs to be met, that either it is a true penal consequence or Skona Adizodu is criminal in nature. But I would like to make the point here that it is criminal in nature, and this begins at paragraph 59 of the appellant factum. The Skona Adizodu process bears the traditional hallmarks of a criminal proceeding, which is one of the major indicia arising out of Gindon that we look at to see whether something is criminal in its nature. There's controversy here. Our friends disagree. They say, and this perhaps goes to the principle that might have been underpinning Justice Martin's question about whether or not which comes first. Our friends say that Skona Adizodu does not look like a Western criminal proceeding because it does not involve lawyers. It does not involve robes. It does not involve language like indictment or maybe even guilt. But it's our submission that those things are all window dressing. When we look at the essential elements of a criminal proceeding, what really makes a criminal proceeding criminal, we see that all of those are still met in the Skona Adizodu process. It still involves a principle that was breached. Here, it was the principle of righteousness. It still involves a finding of what amounts to guilt or a breach by an authoritative decision maker. It still involves the imposition of a typical penal punishment, that being a fine. And maybe if we go to an even deeper level, it still involves a criminal purpose. It still involves redressing a harm that was committed to society writ large by an individual's criminal actions, by their breach of a specific legal principle. We know this to be true also because we can look at the intention of the Ganiyagahaga in creating Skona Adizodu. The process is intended to be criminal. We know this because the authorizing statute says so. The Justice Act, which codifies and authorizes Skona Adizodu, explicitly aims to create a court with original general jurisdiction within Ganawage in all civil, criminal, and penal matters that can hear matters under either the criminal code or Haudenosaunee law. There's also the framework agreement that exists between Falconer and Ganawage, allowing Falconer to refer cases, or rather matters, to Skona Adizodu to address criminal matters or matters that are accepted as criminal in the courts of Falconer.
That they have the jurisdiction to do so doesn't mean it falls within the category, though.
Not necessarily, but it's indicia. It indicates that perhaps it could deal with criminal matters, and as such, here we submit it is dealing with a criminal matter.
You're saying it's within that basket.
Exactly.
Doesn't it frustrate the enforcement of the criminal law, though, to indicate that if this process, the restorative process, is employed, the Flavelian process is not available because of double jeopardy? I mean, it's a race to the prosecution, and a person who wanted to avoid the particularly harsh and punitive sanctions of the criminal code in a traditional courtroom could simply consent to a restorative process and thereby avoid pure criminal sanction.
It's a concern, Justice Pomerantz, and it's a concern that we recognize and take seriously. But that being said, I have two responses. The first is, not all matters will necessarily be referred. Unfortunately, we are limited by our factual matrix that we have before us, but it says that some matters will be referred from the courts of Falconer to Skona Atazodu. So we could imagine a situation, perhaps, where certain very, very serious crimes might not be referred out of this concern of frustrating the criminal purpose. But also alternatively, perhaps the more satisfying answer is that, leaning on the arguments that were made by my friend, this is a reality that we are living in a, to some extent, multi-jurisdictional nation in which we see we are constantly negotiating the extents of self-governance and what that means, and it won't necessarily always be comfortable, but that doesn't mean that we shouldn't endeavor to do it. I will move then to the KRJ analysis, which we've discussed in part through some of the questions, but I'll take a moment to break it down for the benefit of everyone in the room as well. We posit that, as we've articulated, the Wigglesworth test is met. Skona Atazodu is a criminal in nature in its process, and even if this court does not accept that argument, it imposes a true penal consequence in the fine. We now move to the KRJ analysis, which can be found at paragraph 66 of our factum. That being that, now that we are in the zone of Section 11, specifically Section 11H rights are implicated here. There is no controversy between us or our friends, no disagreement that the first branch of KRJ is met, that Skona Atazodu imposes a consequence of conviction that forms a part of the arsenal of sanctions to which an accused may be liable in respect of a particular offense. We submit that it is also both imposed in furtherance of the purpose and principles of sentencing, and it results in a significant impact on Ms. Sheth's liberty interests. Only one need to be satisfied for us to be successful. However, we submit that both are met here. Looking to that second branch, that being the purposes and principles of sentencing, it's clear on the face that the purposes and principles articulated by Section 718 of the Criminal Code are met. The purposes and principles of sentencing, that is. Not only to denounce unlawful conduct, not only to deter the offender and others from committing offenses, but most importantly, to assist in rehabilitating offenders, to provide reparations to the community, and to provide a sense of responsibility.
But are we selling restorative justice processes short if we measure them only by their congruity with the sentencing principles in the code? If we take restorative justice principles seriously on their own terms, don't we reach a very different conclusion?
We don't reach a different conclusion, but we take your point that we should be stepping outside here of merely the purposes and principles that are articulated in Section 718. But even if we take that step back, the purposes and principles of sentencing that are articulated by the Ganyegahaga themselves in the Ganawage Justice Act are also satisfied here. The Justice Act articulates that the objectives of Skona Atazodu are to encourage responsibility, promote understanding and education relating to the harms caused by the impugned conduct, and encourage restitution or making amends. Those are also clearly met here, and we agree that it is within the spirit of reconciliation that we ought to consider the purposes and principles as they are articulated both by the Ganyegahaga and in Section 718 of the Criminal Code. And we submit that all of these principles articulated in both spheres are met by the sanction. I will then turn to the third branch of the KRJ test. The consequences do, in fact, significantly impact Ms. Sheth's liberty interests, and I'll be brief here in the interest of time. This begins at paragraph 77 of our factum. Ms. Sheth faces a ban from the reserve, which is a place where she works, a place where she visits socially to see her friends, and a place which she frequently passes through. This ban is a restriction on her liberty interests. I already articulated the analogy to KRJ.
It's a restriction on her liberty. Is it a restriction of her liberty interests in a constitutional sense?
No.
After Gosselin? Yeah.
No, Justice Martin, not necessarily, but that's not the standard that ought to be applied here. As we saw in KRJ, it need not be an existing right or an articulated right. It need only be an interest. She is interested in attending on the reserve, as we know, because she passes through it, because she works there, because her day-to-day life involves traveling into and through the reserve. Seeing that I'm out of time, I will ask for a brief indulgence to conclude, barring any...
Yes, please conclude. Thank you.
Certainly. Essentially, Justices, The offenses are similar, the legal processes are similar, the punishments are similar. We submit that Ms. Sheth was tried and punished twice for the same offense. It is on that basis that we respectfully request that this appeal be allowed and the decision of the Superior Court of Falconer be restored. Thank you.
Thank you, Ms. Thaitlin. Ms. Jama?
Good evening, Justices. My name is Ikran Jama. My co-counsel is Matthew Farrell, and together we represent the respondent, Ganawage. For generations, the Kanien'kehá:ka, the Mohawk people of Ganawage, have governed themselves according to Haudenosaunee law, anchored in the great law of peace, the Tura Wampum, and the Covenant Chain. Now, the appellant asks this court to apply principles foreign to Ganawage's governance. Justices, this case is about respecting the traditions, the culture, and the principles deeply rooted in the history of the Kanien'kehá:ka. It is about recognizing that the absence of the charter does not mean the absence of rights, only that rights live through the Kanien'kehá:ka's own laws and traditions. And finally, Justices, this case is about who decides right and wrong on Ganawage lands. And the answer must be Ganawage. To override that authority, even in this one case, would be to erode Ganawage's sovereignty and way of life. With this context in mind, my co-counsel and I will have 3 submissions for you this evening. First, I will submit that Section 32(1) of the Charter does not apply to Ganawage. Second, I will also submit that should this court find that the charter applies and that Ms. Sheth's Section 11H right was infringed, then in the alternative, Section 25 of the charter operates to shield any infringement. And finally, my co-counsel, Mr. Farrell, will then submit that Ms. Sheth's Section 11H right was not infringed in this case. Now, I'll begin with our submissions on Section 32(1), which you can find starting at paragraph 10 of the respondent factum. Justices, as our friends stated, the Supreme Court in Gobu identified 4 factors for determining whether an entity qualifies as government for the purposes of charter applicability. And there, the court made clear that the 4th factor, delegated authority, is the most significant. Most recently in Dixon, it was decisive. And so, for that reason, like our friends, I will focus my submissions today on this 4th factor, delegated authority. It is the most important to the outcome of this case, and it is sharply contested by our friends. Justices, there is no delegated authority in this case. And so, according to the jurisprudence, Ganawage is not a government by nature. Our friends argue that the Indian Act provides delegated authority here, but that is incorrect for 3 reasons. First, Ganawage rejects the legitimacy of the Indian Act. They never needed it to grant them an ability they've always exercised. The Kanien'kehá:ka have long governed themselves before the arrival of Europeans, and certainly long before the Indian Act. Second, our friends' reliance on cases like Corbière, like Tepatat, is misplaced here. In those cases, the charter was found to apply to band councils that were exercising the authorities delegated onto them through the Indian Act. Particularly, we're looking at sections 81 to 84 for the purposes of this case, the ability to pass and implement bylaws. But that is not what is happening here, Justices. In Ganawage, there is a band council, but the band council does not have the final say on any law. Through Ganawage's consensus-based system, it is the community, the Ganyega that have the final say on any law. And so, it cannot be said then that the Indian Act delegates any authority in Ganawage when that lawmaking authority once again rests with the community and not the Band Council.
But Justices Cazarer and Jamal state the following. Courts at all levels have recognized that the Charter applies to Indian Band Councils exercising government powers under the Indian Act. So what do you say? I mean, I recognize your argument that you say that the Mohawk people themselves do not recognize legitimacy. But do you have authorities in your favor in this submission?
Well, Chief Justice Martin, I think what is helpful here is to turn to my third point, which is the purpose of the delegated authority factor. And as the Supreme Court stated in a number of cases, in Gobu, in McKinney, in Eldridge, and indeed in Dixon, the purpose of the delegated authority factor is to ensure that Parliament and the provinces do not and cannot escape their charter scrutiny. And so to suggest then that Ganawage in this case is somehow an instrument of Parliament and the provinces, the very same powers that it is seeking to reject, not only fundamentally mischaracterizes this relationship, but again, we are unduly expanding the kinds of entities that are then captured within the scope of 32.1. Entities that are not exercising parliamentary or legislative authority in that sense.
But isn't it in some respects, it's a bit of a paradox, because the argument suggests that if it's delegated, it runs counter to traditional self-government. And so someone wanting to protect the ability to claim self-government might not go the delegation route.
Chief Justice Martin, I understand that concern. And allow me to take us now into perhaps a purposive interpretation of Section 32.1, which also demonstrates our point here, that Ganawage is not captured within the scope of the Charter. And this does not require an argument focused on delegated authority to ease that concern there. This begins at paragraph 25 of the Respondent Factum. So, Chief Justice Martin, our friends would make the same argument here in accordance with your question, that delegated authority should not be decisive in this case. It's not an appropriate or apt case. Even with that, our friends suggest that Ganawage demonstrates some sort of independent government nature that allows it to be captured within the Charter. But with respect, we think that our friends are overlooking an important distinction here. Right? Our submission is not that Ganawage is not a government. Ganawage is a government, and it does govern. But it is not the kind of government that was ever meant to be captured within the scope of Section 32.1. Instead, we submit that the only entities meant to be captured within the scope are Parliament and the provinces. And a textual and contextual reading of the Charter demonstrates this. And here I'd like to make 3 points. The first point is that just looking at a plain reading of Section 32.1 as confirmed by the court in Dolphin Delivery, we can see that the text of Section 32.1 only speaks really to Parliament and the provinces. And again, self-governing Indigenous communities are just not within its textual scope. So Ganawage is not covered by the ambit of 32.1. And Justice Senta, going back to your earlier question that you posed to our friends, what sort of historical evidence do we have here to suggest that this is how the framers intended for the provision to be read in this way? And here we would suggest, we would suggest that we would look at the historical evidence that shows that self-governing agreements between Indigenous communities and Flavel and Faulkner existed throughout the 1970s. The first self-governing Indigenous framework occurred in 1975, the second in 1978. And so the drafters of the Charter, 1982, would have been made aware of self-governing Indigenous communities, but chose to not include them within the textual scope of 32.1. And this only goes to our point, that Indigenous self-governing communities are not intended or were never intended to be captured within the scope of the Charter. But second, we can look to the structure of the Charter as well. We can look to, for example, sections 3 to 5 of the Charter, democratic rights that speak to a parliamentary mode of governance that just doesn't exist within Ganawage. We can look to section 6, mobility rights, where the ability to control international and interprovincial movements, of course, is something that is exhibited and held within Parliament in the provinces, but is not something that Ganawage has control over. And so we can see that the Charter itself speaks to a particular framing, a particular mode of power that it only exists within Flavel and Falkner and the other provinces, and not something that Ganawage or self-governing Indigenous communities wield. But finally, Justices, I'd like to point us to the principle of...
You don't think the Mohawk want to control mobility rights within their territory to determine who can come in their traditional lands, who can... so I don't understand your reference to Section 6.
Chief Justice Martin, of course, I think Ganawage would state that they would love... This is a power that they wield, of course, to control movement within its territory and outside. The point that I'm making, though, is that Section 6 speaks to international and interprovincial movement. It demonstrates that the actual making of the Charter and its governance structures that it speaks to and the powers that it speaks to are directly to Parliament and the provinces and not to Ganawage. I'd like to now take us into the final...
Can the Ganawage not want to have the criminal code and refuse it then on the way that you're putting forward?
Just to ensure that I have the question correct here. So is the question just that Ganawage, if they can just refuse the ambit of the criminal code?
Yeah.
Right. So Ganawage respects and understands and has put into their Justice Act at Section 1 that they recognize Flavel's jurisdiction over criminal law. Ganawage's position here, however, is that when Flavel's criminal laws come into conflict with Ganawage's laws, it is Ganawage's laws that should take precedent. On the final point here, before I then turn to Section 25, barring any further questions on the two submissions that I've just raised, is this point on reconciliation. And so, Justices, we would submit here that by imposing the Charter, what we are actually doing is undermining the principle of reconciliation.
But what about the purposive approach that your friends spoke about? And while this approach is rooted in restorative justice principles and collectivity, there is a coercive element, and there may well be individuals within that community that are the subject of the laws. And I'm wondering what your response would be to the example of the adoption of someone wishing to adopt a non-Mohawk child and the consequences that would flow from that. Wouldn't the Charter be an appropriate mechanism for protecting individuals who perhaps take a different view of what they wish to do in terms of their liberty interest?
Here I have two responses, Justice Pomerantz. The first response is to remember that the Charter is not the sole and superior vehicle in which rights can be defined and protected. Rights are defined and protected in Ganawage, just simply in accordance with their own laws, traditions, and values. And we can see this at work in Ganawage, these kinds of mechanisms that constrain governmental authority. The Kanien'kehá:ka govern themselves according to the Great Law of Peace, their constitutional text. They have a consensus-based system. In which they do grant their communities extraordinary power to pass and make laws and have the final say on law. These kinds of accountability measures ensures and grants the community, again, not just sufficient checks on governmental exercises of authority, but extraordinary checks on governmental exercises of authority to ensure that they do not reach a point where they unduly impede upon individual rights. And so I think the question here is not whether we apply the Charter or nothing. The issue and the question here is whether we apply the charter or respect Indigenous values, knowledges, and capabilities. And I think just briefly before I turn to my second point to my response to you, Justice Pomerantz, the principle of comity might be useful here. So akin to this principle, we would urge this court to offer Ganawage a certain level of respect in its ability as a self-governing Indigenous nation to best be able to define and protect the rights of its own members. The same kind of respect this court and any other court in Flavel would offer other courts, other sovereign entities. But to my second point briefly, it is important to remember that the charter's reach here must be defined by the text and purpose of Section 32.1. And so speaking to our friends' arguments, our position here is that, again, Ganawage is just simply not the kind of entity that is captured within the charter scope. And so we cannot then expand the charter's reach to respond to possible scenarios or hypotheticals. Instead, we need to just remain focused on the text and purpose, which we submit is still to only capture the exercise of authority that flows from Parliament and the provinces.
So are you not in a position to speak to the hypothetical?
So to speak directly to the hypothetical here, I mean, it is again our position that Ganawage does have safeguards within its own communities to best be able to deal with these matters. And
the reason I ask is because once we're talking about offenses and a process that leads to certain consequences attendant upon that, we have Section 8 of the Charter, which would prevent incursions into privacy that are unreasonable. We have the right to counsel to ensure that people understand the right to silence before they speak. We have a rule against arbitrary detention. Shouldn't those have some application in the context that we're speaking of here?
But Justice Pomerantz, I think, and this also brings me to the principle of reconciliation, I think what we're losing here is the fact that Ganawage is perfectly capable of also recognizing these abilities to protect rights. It might not look like the Charter, it might not look like Section 8 or whichever section we're dealing with within the Charter, but they do exist. And again, they exist just simply in accordance with our own values, traditions, and laws. And so while we can accept the idea that perhaps the Charter has apt rights protections, that does not negate the fact that so does Ganawage. And consistent with the principle of reconciliation, we urge this court again to offer Ganawage that level of respect, and not only respect in the sense of respecting their laws and traditions, but recognizing them as legitimate. Because in failing to do so, we are continuing this legacy of subordination that occurred to Indigenous communities during colonization and onward. And so in doing so, we would undermine the principle of reconciliation here. But barring any further questions on Section 32.1,
Could you please turn to Section 25?
Absolutely. I'll now turn to Section 25, which begins at paragraph 85 of the Respondent Factum. Justices, just in the interest of time here, what I'd like to do first is I'd like to turn to other rights, which begins at paragraph 88 of the Respondent Factum. But at this stage, I'd also like to make clear that the respondent is making two submissions beforehand. The first is, again, that the Charter just does not exist. And the second is that Ms. Sheth's Section 11H rights were not infringed. And in order for us to be successful overall, we only need to be successful on one of these 2 points. At this stage, we are assuming that the respondent has failed on both points, and then we get into the question of Section 25. But with respect to the issue of other rights, we would submit that the right to govern over criminal matters is both an Aboriginal right, which I will rely on my factum to explain, and an other right. And the court in Dixon made clear that in order for something to be an other right, only 2 things are required. First, the right must exist, and second, the right must protect some sort of Indigenous difference. And both are met here. First, the right to govern over criminal matters certainly exists, as demonstrated through the enactment of the Justice Act and the Skana Onizandu process. But second, it does protect some sort of Indigenous difference. As the Kanien'kehá:ka have said for themselves, restorative principles are rooted in their own cultures, and the further they stray from restorative principles, the further they stray from their values of community and collectiveness. Barring any questions on other rights, I'll now take us into the final portion here, that Ms. Sheth's Section 11H right and Ganawage's right to self-govern over criminal law matters irreconcilably conflicts. And this begins at paragraph 95 of the respondent factum. But at this stage, Justices, our argument here is quite simple. Every time an individual is tried under Flavel's criminal justice system or Falconer's justice system, and then comes through Ganawage's justice system on the same matter, they will always be able to invoke Section 11H. And by doing so, Ganawage is unable to realize the actual outcomes of the Skane Ane Zandu process. And because of that, because the outcomes may not be ever realized, Ganawage simply has no real control over their ability to govern over criminal law matters, making it both illusory and ineffective.
Just let me ask you the last point before you sit down. Who amongst you will address the question of what happens if the Ganawage goes first in terms of their restorative justice model?
May I ask the court for a brief indulgence just to answer the question?
Absolutely.
I can answer this question,
Thank
Chief
you.
Justice Martin. So from our position here, especially when we're dealing with irreconcilable conflict at Section 25, for example, if it were the case that Ganawage tried Ms. Sheth first, and then Ms. Sheth went into Flavel's system, our position is that Ganawage just simply is not a part of this litigation anymore. And so with that respect, we can see how there might be an argument when we're dealing with irreconcilable conflict that perhaps, as our friends may suggest, there is no irreconcilable conflict if that were the case. But our position is still that in this case, if it were in this case and in cases like this, Ganawage will always be barred from actually exercising its ability to govern over criminal matters. And my friend can continue on this point and elaborate on this point with respect to his Section 11H submissions specifically.
Thank you very much.
Thank you.
Mr. Farrell?
May I proceed?
Yes?
Good evening, Justices. My name is Matthew Farrell, and I'll conclude submissions on behalf of Ganawage. Justices, in this case, the appellant seeks to impose Western standards of criminal law onto Ganawage. They seek to say that the only way a nation could possibly deal with the social problem of crime is through punishment. And Ganawage rejects that idea and seeks that this court affirm its right to practice criminal law in its own way. My broad submission here is that Section 11H of the Charter does not protect Ms. Sheth, and there are three parts to that submission. First, that Ms. Sheth is not charged with an offense, and so therefore Section 11's broad protections don't apply. Second, that Ms. Sheth was not punished, and therefore Section 11H in particular does not apply. And finally, and even if those other two submissions are rejected, that the punishment is not duplicative, since they involve different conduct and different legal duties. I'll begin on the issue of whether Ms. Sheth was charged with an offense, and this begins at paragraph 47 of our factum. Someone is charged with an offense, according to Wigglesworth, when either they are A, subject to a proceeding which is criminal in nature, or B, subject to a consequence which is a true penal consequence, and I'll take you through each of those. On the subject of whether this is a proceeding which is criminal in nature, the appellant submits that this is a proceeding which is criminal in nature, and it's in the principle of reconciliation to accept that it is, despite the window dressing that looks different, they say. In our submission, this is not merely window dressing. So there are significant differences between Skane Ane Zandu and traditional Flavelian criminal punishment. Voluntariness is one aspect, that this is an opt-in system at first instance. This is categorically opposed to the coercive pressure placed on individuals by criminal law. And indeed, it amounts to one of the hallmarks of a criminal proceeding that the court found to be relevant in Ginden. But secondly, the lack of lawyers isn't just window dressing here. It speaks to a fundamental difference in the way that the proceedings are carried out. This is dispute resolution, where everyone has a say, and that's exactly how Ganawage described it, dispute resolution.
But can I stop you there? Is you say the absence of lawyers makes it not criminal in nature. What about the view that the absence of lawyers is simply evidence that this is a terribly unfair process that is criminal in nature without fundamental safeguards that are in the interest of natural justice that we would all recognize?
Justice, if, let's say, the Flavelian government just created a system that was criminal law but just took away the lawyers, we'd agree with you. But the lack of criminal lawyers in this case speaks to a difference in the way that the system is carried out. That the principles and legalese is pared down to allow the individual themselves to participate in a much more fulsome level. That there's more collaboration between the decision maker and the individual in question. So we would agree that this would be a worry if this was a more structured system, but the fact that it's more collaborative of dispute resolution speaks against the principle this is criminal in nature. Now, our friends say that because we're dealing with a legal principle here and a breach of a legal principle, it must be criminal in nature. But I want to be very clear that the Supreme Court of Canada in Gindin found Income Tax Act proceedings, even those which deal with tax fraud, are not criminal in nature. Why? Because even though they deal with the social problem of crime, they do so from the perspective of decreasing future crime rather than punishing for it. Similarly here, dispute resolution that Skana Anazandu represents is not characteristic of the sort of punishment that is imposed under traditional Flavelian criminal law. And so again, the lack of lawyers, the lack of punishment, or per se, the lack of intentional punishment, speaks to the difference between these two systems. The last reason I'll give as to why this system is not criminal in nature is that there exists a separate court system in Ganawage. Proceedings can be referred after or during Skana Anazandu to these separate court systems which are meant to deal in a much more traditional way with criminal law. What this suggests is that Ganawage itself intended there to be multiple streams for resolving disputes. One of them restorative, anti-criminal, or not anti-criminal, but perhaps non-criminal, and one of them which is more traditionally criminal in nature.
Can you help me there? You've said that this process is non-criminal. How do you reconcile that with the assertions that you make under Section 25, that it's the right to govern over criminal matters that grounds your Section 25 right? How can you help me reconcile how these are criminal matters that are not criminal in nature?
Absolutely, Justice. And I'll return to Gindin here. The mere fact that we're dealing with criminal law. So our claim is that Ganawage has the capacity to self-govern over criminal law matters. But Ganawage goes about exercising that right in a fundamentally different way than Flavel does. It uses dispute resolution, which shouldn't be characterized as criminal in nature under the Flavelian Charter. But we still do accept that we undertake the right to govern over criminal law, just in a fundamentally different way than Flavel.
May I ask, in this case, the appellant consented to the process because she wasn't aware of her right to Section 11H, which you assert she doesn't have anyway. But why would someone consent to the process after they have undergone a criminal trial and criminal punishment in the Flavelian system?
Justice Pomerantz, that's a good question. It may be because she wants to rebuild the bonds that she broke with the community. We don't have facts to this effect from Ms. Sheth herself, but as you point out, the fact is that she did consent to this voluntary process at the start. And so what this suggests is that there was some separate reason that she was agreeing to this process beyond just being punished for it, like we already talked about.
But can we get back to, is there anything that has to be singular about the purpose of a justice or criminal justice system? It's either restorative or dichotomously it's based in retribution. I mean, why can't we have a mixture of both in each?
Certainly, Justice Martin. I'll make 2 points on that question. The first is that Ganawage has clearly attempted to primarily shy away from retribution. And I say primarily because we agree. Certainly a $500 fine could have some non-trivial deterrent effect. But the Supreme Court of Canada has been clear that we should be considering the primary purpose of a consequence. And this is most relevant at the KRJ test, which I'll take you to after finishing up on true penal consequences. But the point I want to make here is that according to Rogers and then subsequently KRJ, we should be considering the primary purpose of a consequence. In that case, it was a DNA order, which, yes, did have some non-trivial deterrent effect. People don't like their DNA being taken, but the primary purpose was to stop future crime, so it shouldn't have been characterized and wasn't characterized as punishment. So we're not saying that there is no retributive aspect of the Ganawage system, merely that the primary cause of this system is not retributive in nature, unlike the Flavelian justice system.
And what weight should we give to declarations about what their goals are, or what even the goals of the Western justice system are? Or do we have to measure them against what the justice system actually does?
Certainly, Justice, we should consider both. At the stage of asking whether something is criminal in nature, however, we're primarily considering whether it's a criminal purpose. I'll take you now, however, to discuss whether there are true penal consequences engaged, and then we'll discuss whether the effect happens. This begins at paragraph 52 of our factum. And I will rely primarily on my factum for this submission, akin to the appellant, but I want to make 2 points clear. The first is that, according to Wigglesworth and then carried through to KRJ, the true penal consequence test is an indisputably high bar that essentially only applies to prison sentences and a fine which by its very nature appears to be penal. And in our submission, that isn't met here. One relevant consideration, not the only one, is the magnitude of a fine. So in Martineau, a $300,000 fine was found to be not enough to be a true penal consequence. Subsequent courts like the British Columbia Court of Appeal in Samji found a $33 million fine not to be truly penal in relation to the sort of consequences or the sort of conduct that they were trying to address. Here in our submission, impaired driving is quite serious. It risks the potential death of members of Ganawage's community. And so a $500 fine in recognition of that harm done to the community is not a true penal consequence. It's a representation of restitution, which I'll explain a bit more.
What do you say to your friend's argument about the knock-on effect?
I'll make 2 points on the knock-on effect. So the knock-on effect, of course, being that if Ms. Sheth doesn't abide by the consequences, then she will be subject to an order of banishment. First, we can test the appellant's characterization of what Boudreau means for this case. Because Boudreau dealt with a essentially mandatory victim surcharge, wherein the issue was, or one of the issues was that many individuals couldn't pay the victim surcharge. And since it was mandatory, there was no way for the court to stop that from happening. And so the knock-on effects of not being able to pay necessarily accrued in many cases. Here, however, the consequences are tailored, and Ms. Sheth had the opportunity to participate in the process to tailor the consequences. This is why, at paragraph 31 of the facts, she says that she will abide by the consequences in the event that they are upheld. So we shouldn't be considering this knock-on effect because it's not going to apply in practice. There's no requirement for it to apply in practice, and she's agreed that it won't. The second brief point I'll make here, and I'll say many of the same things when we get to the punishment stage, is just Ms. Sheth had no necessary legal claim to be on Ganawage land. In the same way that if the law school wanted to kick individuals out for any reason or no reason at all, they might be able to, Ganawage has the capacity to say, you're no longer welcome here on account of this failure to abide by the principle of righteousness. With the leave of this court having established that Ms. Sheth was not charged with an offense, I'd like to move on to discuss punishment. But I would like to make it clear that if you're with me on this stage of Section 11, then it would be unnecessary to continue to dispose of this appeal. And so the stage of punishment will begin at paragraph 55 of my factum.
I mean, I understand your analogy to trespass is what you're doing there. But it's still a deprivation of a freedom to go somewhere. Yes, putting someone in jail is the ultimate deprivation because you're containing. But to the extent that you say you cannot go somewhere, and there were old criminal code things about banishment and exile and those things as well. Why can't it be penal?
Justice Martin, I'll make 2 points there, and this sort of bridges the divide between my submissions on true penal consequences and punishment, since the courts, of course, have upheld that distinction. In terms of a true penal consequence, the courts have been very clear that only fines and prison amount to a true penal consequence. And so we can consider, for example, driver's license revocations, which were not found to be a true penal consequence, despite of course, constraining someone's ability to move somewhere. And so it doesn't apply as a true penal consequence. At the stage of punishment, it might be punishment if we, A, accept that we should consider the banishment as a knock-on effect, which I've argued we shouldn't, and 2, if it amounts to a significant restriction on liberty. And if you will, I'd like to move on to discuss that part of my submissions, and that's going to begin at paragraph 69 of our factum. To situate ourselves while we turn there, this is the third aspect of the KRJ test. So the appellant has to prove that one of either a significant restriction on liberty or imposed in furtherance of the principles of sentencing. And so I'll address this third part first. Here, I think it's useful to turn to a comparison of 2 Ontario cases to help us situate whether something is a significant restriction on liberty. So I'll discuss the case in Huyer, where the restriction that was imposed was found to be a punishment. And the restriction in question was an individual who was not allowed to work in a job that involves handling real property of other people, which essentially meant that that person couldn't work in any job because that was his field. And so that was a significant restriction because it prevented any of those choices. The same consequence in Duell, an Ontario Superior Court case, was found to not be a sufficient or significant restriction on liberty because the individual in question was retired. And so he would have been choosing to work in the first place. It wasn't taking away many choices for him. In our submission, this case is closer to Duell because Ms. Sheth has other options through which she could work. She already has a part-time job off of the Ganawage Reserve, and she works as a freelancer, and so could conceivably find work as a freelancer to supplement that part-time job outside of the time that she's working on the weekend in Ganawage. But secondly, just the temporarity of the consequence speaks to how it's not very significant. She's only required to abstain from going to Ganawage for these 4 weeks. She's only required to go to Ganawage for 4 weekends. And a $500 fine is meager compared to other fines in the jurisprudence that have been found not to be punishments. And so our submission here is that this was not a significant restriction on Ms. Sheth's liberty, though it of course is a minor restriction on her liberty. Trivial, we accept that.
Do we look at totality? Do we look at this punishment or consequence together with the consequence imposed in the Flavelian court in assessing what the impact is on liberty?
Justice, in our submission, we shouldn't in this case, but there could conceivably cases in which we do. And so I'll address that first point, then I'll get to the cases in which we might. In this case, we shouldn't because they are imposed as part of sort of separate proceedings, wherein Ganawage has gone in and talked precisely to Ms. Sheth, and she's had the ability to make submissions on her own consequences and agreed that she's able to abide by them. We can conceive of a different case, for example, where Flavel attempted to prosecute Ms. Sheth over and over again, let's say imposing $10 fines each time. In that case, maybe we should consider it cumulatively because there's some desire by the government to impose these fines all as one. But here, since they're separate organizations, it's fair to say Ganawage is imposing this consequence in relation to Ms. Sheth, separate from Flavel's consequence. With your leave, I'd like to move on back to section 2 of the KRJ test. And there's an interesting question here about whether the test should apply here. The question is whether Ms. Sheth's consequence was imposed in furtherance of the principles and purposes of sentencing. And our submission is that the test should be constrained slightly in the context of restorative consequences. We should only consider those consequences as punishment that confirm the punitive purposes of sentencing, denunciation, deterrence, and separation from society, not those that are restorative. And there are 2 reasons for this. Both stem from the incompatibility in general with restorative justice and rehabilitation and penal consequences. First, the impact of punishment and restoration are often opposed with each other. The Supreme Court of Canada found in Gladue, for example, that prison sentences are often incompatible with the outcome of restorative justice. And in Proulx, the court found that restorative justice often requires, in some ways, lower sentences like conditional sentencing orders. Now, Justice Martin, to return to your previous question, that doesn't mean that there is no overlap. That doesn't mean that restorative justice isn't often imposed as part of punishment. I'm merely saying that when we're considering the definition of punishment, which is what we're concerned with here, we should not include a concept which in many cases is opposed in practice with the concept of punishment, since we're at issue's definition here. The second reason, though, is that the purposes of restoration and punishment are often at odds. Restoration seeks to uplift an offender. to repair the broken bonds between the offender and the community. Punishment, in some sense, seeks to make an example out of the offender, to say that others shouldn't do this or that they shouldn't do it in the future themselves. The court in Lacasse, for example, found that offenders should be made sensitive to harsh conditions. Those are fundamentally opposed, to say that on one hand, an offender should be uplifted, and on the other, that they should fear the justice system. And so, just to briefly put a pin on that, restoration is the primary purpose of the sentence here, and as I mentioned earlier, according to Rogers and KRJ, we should consider the primary purpose. Even this $500 fine is imposed for the purpose of restitution, which according to Gladue is restorative in nature, because it involves recompense for the harm done, the fear caused to the community from impaired driving.
But when there's teeth, as your friends say, to something that you can argue, and you're doing very ably, that it has a restorative kind of basis. But one could also argue that if you're forcing labor in a garden, that's also on liberty. And if the teeth is effective removal from the community, isn't that also a form of punishment?
So I'll make 2 points here. The first is just on the conception of the test. It wouldn't make it punishment at the stage of the purpose of the sanction, which is the second step of the KRJ test. But going back to the third step, the restriction on liberty, it might, right? So we can imagine a situation where, say, Ms. Sheth was a member of the Ganawage community herself. Being barred from the community might be a significant restriction on her liberty or security of person. But that's just not the facts here. She works part-time in Ganawage as a freelancer, a job she could undergo outside. She has a friend in Ganawage who she could see outside of Ganawage. These aren't taking away significant choices that she would be able to make, and indeed, that consequence only applies for 4 months. With your leave, with my brief amount of time I have left,
Yes,
I'd like to
please.
briefly address whether these consequences are duplicative. And here our submission is that they aren't, because the criminal code offense deals with fundamentally different behavior to the Ganawage offense. The criminal code, of course, deals with the state of impairment, but does not deal with the consequence on Ganawage's community, the value that the garden itself had to that community. This case is analogous to the Supreme Court's decision in McKinney, where there were 2 offenses, one for hunting out of season and one for hunting with lights. Of course, hunting with lights can only happen at that time if he was in fact hunting out of season previously, but they were nonetheless different offenses that gave rise to different consequences and not double jeopardy because they were based on different underlying delicts. They were addressing different wrongs. In this case, we're addressing the harm to the community on one hand and the potential harm to broader Flavelian society on the other. So they're different offenses dealing with different conduct, analogous to McKinney.
But weren't they both dealing with the potential harm of someone who's driving while intoxicated? I mean, and the people in Ganawage are obviously included in what Flavel is trying to protect.
If I might have a brief indulgence to answer.
Yes, I'm not going to ask you a question and then stop the mood there.
The fact that one group that might have a claim to prosecution is included in a separate group doesn't mean that they don't each have a claim. And so I'll make that clear with the example of Wigglesworth, where there was an individual who was tried both under Canadian law and also by a professional organization. The professional organization, of course, included within broader Canadian society. But they had a unique claim to prosecute based on the different obligations owed from the individual to the professional community versus Canada at large. Here, the destruction of the garden itself gives rise to that distinct obligation that isn't even considered under the Flavelian conduct of impaired driving. It doesn't consider the impact, and that's relevant here for deciding whether it's a separate offense. If I might briefly conclude.
Please summarize.
You heard from Ms. Jama, and now you've heard from me, that Flavelian criminal law cannot apply to Ganawage. Its charter is incompatible with Ganawage's, and indeed its concepts of punishment and retribution are incompatible with Ganawage's restorative framework. Ganawage cannot accept a system which eschews restoration and eschews reconciliation and continues to prioritize Flavel's view on those very systems. And it's for that reason that we request you dismiss this appeal and restore the decision or affirm the decision of the Falconer Court of Appeal. That concludes our submissions.
Thank you. Wow, thanks very much. We're going to take a little bit of a break before we come back and give some comments on what were exemplary performances. Thank you.
So the judges will be back in a few minutes. We'll ask you to sit tight a little bit longer, and then once the judges have given some feedback, we'll ask you to move on to the reception, but just a little bit longer. Thanks for your attention.
Thank you. Would everyone please rise for the justices? Thank you.
Thank you. Please be seated. It's our happy task now to give some general comments about what were stunning performances on what is an unbelievably difficult problem. It is a problem that has many moving parts, many important sections, many sections that don't have sort of settled content, and in an area where the parts are moving themselves. And so it was a nice problem in the sense that it was difficult. It allowed, I think, equal opportunity difficulty in terms of a balanced problem. And it also required the mooters to both be rigorous about existing jurisprudence like Wigglesworth and to talk about a divided jurisprudence like Dixon. All right, so that's a very good and important matter. I'm going to make a few overview points, and then my colleagues are also going to add their voices. There is nothing more important in mooting or in advocacy than structure, and your structures were fantastic. I never didn't know where you were, okay? Even when we brought you off with questions, you always brought us back. I'm on the second part of this test. That's just exceptional, very advanced advocacy. You started out with outlines, and everybody stuck to the outlines and then brought us back to where we were in the analysis. That is really helpful, and it shows a great sophistication because it shows us you understand the interrelationship between the arguments, and that's crucial. You each started with a statement of issue, and the statement of issue was meant to be capturing of our interest, and it was, but it wasn't over dramatic or rhetorical to the point that you think, oh, okay, now what are we into here? It was very clear we were into a very solid legal argument on important points. You used great wording, very sophisticated language, very tight sentences to convey so much knowledge. And what does that do? Well, we know you know what you're talking about. We know you've done the work. We know you know the cases. And guess what? We listen harder because we're trusting you, because you have done the work and you are that well prepared. And you have shown an advanced understanding of where the concerns are. And certain times you've said, yeah, that's a bit of a problem, but here's my answer, right? And so that was very impressive. I loved the way you answered questions, okay? You all got hard questions. They weren't mean, but they were hard. and each of you did a superb job on questions. I just, Ms. Zaitlin, I loved your waiver answer, okay? Loved it. Here's the cases, here's the principles, here's the facts, here's my argument, and here's why I'm right, okay? And you all did that really, really well. You spoke to the hypothetical. You brought us back to things that you had heard other questions. You spoke to them and made sure that we were listening in a way that was really compelling. Mr. Farrell, knock-on effects and the way you had those questions, the distinguishing features of the various cases just at your fingertips, just there. It's just like, yeah, well, of course we all know this. And you would hope that, but you're the one that's the guide dog in the argument. So that's what you're showing. And Mr. Jane, I thought you did a superb job on almost every question, all right? When I went through and was looking at the different ones, I couldn't pick a particular one because they were just so well done. The only thing I will say that I will giggle about is that my jurisprudence is trending.
I echo all of those comments. This was a difficult problem. I once heard it said that when a legal issue is like an onion, you can peel away the layers, and often it's like an onion because it makes you cry. And this might have been one of those problems, but you dealt with it impeccably, and your arguments were sophisticated. I wanted to comment on the written material because the facta were absolutely tremendous, and never underestimate the importance of written argument, because that's when you get a chance to capture the court's attention without being interrupted. And I don't think I'm giving away any major secrets when I say that after reading written argument, judges often walk into the courtroom with a lean one way or the other. And of course, we keep an open mind and listen to arguments carefully, but that's your chance to really grab the court and make an impression and try to get the lean in your direction. And quite frankly, it was hard to lean because both facta were really tremendous. I'm going to say that your oral arguments were spectacular, and I mean that. That is not an overstatement. Each one of you has a tremendous style, your poise, your mastery of the material. And what I really liked is that all of you were comfortable. You were conversational. You weren't rigid. You knew the material. It was like having a conversation with you, a very sophisticated conversation. And I thought that was marvelous. It was just a delight to listen to each of you. I agree. I was going to make the point about questions. Those were beautiful answers. I used to come up with devastating answers to questions, usually at about 3 a.m. when I was lying awake, thinking of the case and reliving it in my mind, but you had them at your fingertips, and I really admired how you did that. I also really liked the fact that I think all of you, when you were making your submissions, managed to go back to a question that had been asked in the past, which was great because questions really signal what the court is thinking about and where the court's concerns are. And you not only answered the questions well, but you came back to them and used them to facilitate your arguments, which was really, really great. I also thought that you showed great flexibility. And you really curated what you had to say in very short periods of time. So when you only had 2 minutes left, you were able to decide which of the 30 points that you wanted to make you would focus on, and you chose really well. And so, you showed the flexibility. That's so important in oral argument, particularly when you're the respondent, because you're really listening to what the appellant has to say. And you picked up the window dressing language. So you were listening, and you were definitely responsive. Because, when you prepare an oral argument, there are a couple of arguments that happen. One is the one you prepare, which is you standing up and making your points seriatim without any interruption. But the real world is one where there are judicial headwinds and sometimes a perfect storm. And I think all of you would be able to set sail and stay on the boat no matter what the conditions are. So bravo.
I agree with everything my colleague said. First, I want to thank the Moot Court Committee for giving us such a beautiful and intellectually stimulating problem. It was just tremendous. It was a joy to work with. And I want to thank the Mooters for giving me in particular such a lovely homecoming. In September 1996, I was sitting in the back of a much less august room watching the third years do their Grand Moot. In September of 1998, I was lucky enough to do the Grand Moot. Let me be clear, if I was in law school today, I would be back in the audience. I would not be up here. You four were spectacular. You gave us incredible gifts of terrific factums to work with, wonderful, thoughtful answers to questions. There's nothing more we could have asked for. And I hope that to the 1Ls in the room, you appreciate the gift that you've been given of such a wonderful display of advocacy. And I hope that you will take this opportunity to reflect on it and use it to inspire your own learning, whether that is through legal clinics or just in course or through mooting, which is a terrific way to engage with the material. I hope you see the gifts that were on display tonight as something you can aspire to and energizes you through the remainder of your law school term. And I just want to thank all of you for being with us, and particularly to the committee and to the mooters for such a wonderful evening. Thank you.
Adjourned.
At this time, we'd like to present some gifts to the judges and the mooters for all of their time and effort on behalf of the Moot Court Committee, on behalf of the mooters, on behalf of the Faculty of Law, and on behalf of McCarthy Tatro.
Thank you very much. We get the same present? Oh, okay. No dropping them. Oh, very interesting. Oh, good. Oh, my God. That's pretty beautiful.
And with that, we're happy to announce that the reception has begun, and we'd like you all to please make your way to the Rowell Room to take advantage of the wonderful food and drink we've got out there. If you'd like to see the mooters and the judges, they'll be up there shortly as well. So if we could just keep it moving, that'd be great. Thank you all.